All right, good morning. We'll get started. So today's May 13th, 2025, Corrections Policy Committee. We will read our public announcement. So this is a public meeting subject to public meeting law. Be digitally recorded. Deliberation of issues will only be conducted by Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. So we will go first into introductions.
When I call on you, please state your name and who you represent for the record. We'll start with you, Chair English.
Matt English, Hood County Sheriff, representing Oregon State Sheriff's Association.
Vice Chair Cameron.
Jennifer Cameron, representing non-management parole and probation in Lynn County.
Member Aldridge.
Josh Aldridge, Jackson County Sheriff's Office, representing the Sheriff's Association, Oregon Jail Command Council.
Member Boren.
Mark Warren, public member.
Member Frasco.
Lori Frasco, Department of Corrections, AFSCME.
Member Frost. Member Frost, can you hear us?
Oh, there you go. John Frost, Oregon Department of Corrections, AFSCME's non-management representative.
Member Hartford.
Mike Hartford, Marion County Sheriff's Office, representing Oregon Association of Community Corrections Directors.
Member Hunter.
Nick Hunter, Marion County Sheriff, representing the Oregon State Sheriff's Association.
Member Langley.
Ted Langley, Lynn County Sheriff's Office, representing OSSA Jail Command Council.
Member Mays.
Officer Michael Mays, representing Oregon Department of Corrections, Eastern Oregon Correctional Institution.
And Member Steffen.
Brian Steffen, Chief Security of the Oregon Department of Corrections, representing Mr. Mike Reese, Director.
And now for staff introductions, I'll go first. Juan Lopez, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Melissa Langbacho, DPSST Professional Standards Case Coordinator.
Jennifer Lavario, DPSST Professional Standards Compliance Coordinator.
Cindy Park, DPSST.
Phil Castle, DPSST.
Catherine Kelpine, DPSST.
Sam Tanny, DPSST.
Maria with DPSST. Jennifer Howell, DPSST. Kathy Fink, DPSST.
All right. We will move into approval of the minutes from our last meeting, February 11th. Everybody have a chance to look over those. Any changes or corrections that need to be made? If there aren't any, I entertain a motion to approve the minutes.
Mr. Chair, I'll make that motion for you to approve the minutes from February 11th, 2025.
Thanks. Is there a second?
Jennifer Cameron, I'll second that.
Thanks. Erica, if you want to do roll.
Yeah, we are voting on a motion to approve the February 11th, 2025 meeting minutes. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Boren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
Thank you. All right, we will move into administrative closures and consent agenda presented by Melissa Langbacho.
Thank you. Melissa Langbacho for the record. DPSST completed the review of 2 cases and is recommending administrative closure of those cases. The 2 are presented on a consent agenda for the committee's consideration. The department is seeking a vote to approve the recommendations or return the cases for further review to the committee. Thank you, Mr. Chair.
Thanks. So I did have a question on one of them, Bonnie Kessel. So kind of reading the report that was done, and I understand the burden of proof has to prove intent. I think, you know, that DPSST found that she did provide false statement, and kind of reading the summation on the first page, I was just concerned that there maybe was intent there. Are you able to provide a little more information on that?
Unfortunately, not off the top of my head, but in reading what the analysis was, that I believe that we didn't find that there was enough information to show intent, because there was some information that showed that she was being truthful when she provided a statement that was ultimately incorrect. And I think because of that, where some of the information aligned with her perspective and acknowledged that it was false, that it seemed more like it was an unintentional statement and didn't meet that criteria. I am happy to bring the case back to the committee for further review, if that's something that you would like to look at further.
Matt English for the record. I want to hear from other committee members, but that was, you know, it may just be my opinion, but I kind of reread that one a few times and just wanted to, kind of had some question about it.
Nick Hunter for the record, I had the same concerns. There seems like there's some omissions in there that definitely lead to the possibility of intent. So I don't know if that's a motion, that we make a motion to bring that back for a full review.
Catherine Kalpine for the record. Absolutely, and we can do the full packet, so you guys can vote to not accept it as an admin closure. We can come back so that you can see the entire interviews and draw, you know, informed decision that you can make, and so definitely can do that.
And Matt English for the record, I'd also just want it to be on the record that I'm certainly not questioning the investigative work that's been done here. I'm just concerned about the behavior.
Yeah, absolutely.
So I'll make a motion, Nick Hunter for the record, I'll make a motion that we bring the Kessel case back for a full review and do not accept it as an administrative closure today.
Brian Sefton for the record, I'll second that.
Is there any further discussion or opinions on that before we move to a vote? Hearing none, Erica, if you would do roll, please.
All right, we are voting on a motion to remove Bonnie Kessel from the administrative closure list, bring it back to the committee. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Sefton.
Aye.
Motion passed.
All right, thanks. So we do have the other case, which is Nathan Lelek, that is on the administrative agenda. So if there aren't any issues with that, we need a motion and a second to approve that consent closure.
Brian Sefton for the record, I move to approve that consent disclosure.
Mark Bourne for the record, I'll second.
All right, thank you.
We are voting on a motion to approve the remaining administrative closure. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Sefton.
Aye.
Motion passed.
All right, thank you. So we're going to skip around a little bit on the agenda this morning because we do have one of the folks in person and then two others online. So we are going to start with the case on Bradley Herrera. will be our first one, so that would be
Book 2, first one.
number 8 on the agenda. Good morning. So I will turn it over to Melissa for case overview, please.
Cindy's
Cindy.
taking this one.
Thank you, sorry.
Good morning. A professional standards case was opened regarding Bradley Herrera after the department received an application for training in a criminal history reporting form in which Herrera disclosed previous criminal dispositions. Because the criminal dispositions occurred after Herrera's prior employment as a public safety professional in 2008, it's being brought before the Corrections Policy Committee for review rather than the Applicant Review Committee. On October 3rd, 2014, Herrera was found guilty of the offense of reckless driving in Harney County, Oregon, after a report that on July 24th, 2014, Herrera swerved his vehicle toward an individual on the roadway. Herrera was sentenced to 18 months bench probation, 60 hours of community service, and his license was suspended for 80 days. On February 28, 2022, Herrera was charged by the Harney County District Attorney's Office with the offenses of assault in the 4th degree, harassment, and criminal trespass in the 2nd degree, after a February 2nd, 2012 incident in which Herrera drove to an individual's home and got into a physical altercation with them. Herrera stated he found the victim's vehicle at his home when he came home early from work, and that the victim left before Herrera could get out of his car. On May 2nd, 2022, Herrera pled no contest to the offense of harassment, and the remaining charges were dismissed. Herrera was sentenced to 12 months bench probation, completion of an anger management program assessment, and fines and fees. Moral fitness violation, the department did not identify sufficient evidence to support a finding of dishonesty or misuse of authority. However, we did find misconduct in that Herrera violated criminal law and has criminal dispositions for reckless driving and harassment. Herrera threatened another person by nearly striking them with his vehicle multiple times. Herrera harmed another person when he subjected them to offensive physical contact. Mr. Chair.
Thank you. All right, Deputy Herrera, so you will be given 5 minutes to talk with the committee, but there's no questions of you or of the committee. And Cindy will start the timer whenever you're ready.
Okay. Well, committee members, others in attendance, thank you for your time for allowing me to speak today. As Mr. English has said, my name is Brad Herrera. I'm a deputy with the Harney County Sheriff's Office. I'm also a current student here at DPSST with class PCL 066, and I apologize, I'm a little winded from walking from scenarios. So, as you're all aware, as disclosed, this is a hearing in regards to my F5 and my F28 applications during the application process. The events and the reports are accurate completely. I do not dispute this at all. Due to time constraints, there are some backstories to these, but I have a tendency to go on and on, so I'm just going to cut to the chase. Yes, I was convicted of reckless driving, which is a Class A misdemeanor, by a 6-jury person jury of my peers, and that was through my request, not the not through anything with the courts. Ordered 18 months bench probation, 90 days suspension on my driver's license, 60 hours community service, and fines and fees. I was released from probation early for completion of these orders by the court. And that was for the 2014 incident. I will go a little bit into depth on the 2022 one because that is the most current one. I did what I did because I felt that my family was in jeopardy. The man in question was a registered sex offender. Multiple occasions I told him to stay off my property. He did not. I mentioned this to law enforcement. They did what they could, but it wasn't effective. So, as a result of that, I did what I did. I felt justified in what I did, but it doesn't excuse the fact that in both instances, in the 2022 and the 2014, I broke state law. Been honest with the arresting deputies and officers in both cases. Been honest with the hiring committee as well as the Harney County Sheriff during this process of, coming on with the Sheriff's Office. I just wish there was some other way that I would have been able to do it other than resorting to the actions that I presented. But now here I sit as a deputy representing Hardin County. I know that I'm going to be held to a higher standard. I am a sworn deputy and under code of ethics conduct through not just my agency but through DPSST as well. So that being said, any future incidences that come up, whether they be similar or completely different, will be handled in a legal standard appropriately, taking police, lawyers, and courts in as such. What I've learned from this is this doesn't excuse my actions. I justified it, but the justification doesn't beat state law. Unfortunately, I am sorry for what I did. I did go to anger management. I also have been to a program called Celebrate Recovery, which helps out with multiple problems such as anger, drug, alcohol, so on and so forth. And I continue to do these programs to maintain that. So future incidences, working in corrections, it's definitely going to be challenging as far as my temperament. So I felt the need to keep doing with my counseling as I promised the courts. And I thank you guys again for your time today.
All right. Thank you, Deputy. All right, so does the committee feel like we have enough information to move forward on this with the information presented in the staff report? All right, seeing consensus, are there any objections if we adopt the staff report?
Chair English, I just wanted to, this is Brian Steffen for the record. I think on page 2, there's just a typo, and I just wanted to confirm that it wasn't a different incident. It was, I think it says 2005 at the end of, or it was released from probation early on October 14, 2005, so I assume
that was 2000.
By the other dates, it should have been 2015.
Yeah, that's what I thought.
Thank you for pointing that out.
Other than that, Chair,
Okay, with that correction, hearing no other objections, I would say there is consensus to adopt the staff report and move forward. So I will open up this case for discussion. And during that time, we can identify any aggravating and mitigating factors. Please remember to state your name for the record.
Nick Hunter, for the record, aggravating factor, pattern of behavior. You have an almost, do math in my head here, 6-8 year separation between two incidents. I'll also throw another aggravating factor. I believe there was dishonesty during the 2014 incident where Mr. Herrera was convicted. If you look at the stories that he provided leading up to the conviction, there was clear dishonesty in how he recounted the events versus how the court saw those events versus how the witnesses saw those events.
Brian Steffen, for the record, mitigating factors. The hiring lieutenant wrote a letter to the committee on Herrera's behalf. Herrera disclosed on his applications and was honest. Aggravating, said, let's see, he still feels justified in what he did regarding the assault. However, mitigating, he acknowledges that going forward he would act within the law, use courts. Mitigating, he attended anger management. Mitigating, he attended recovery program and continues to participate in the program and counseling. Aggravating, repeated incidents of anger causing legal issues with the police. And the guilty of harassment was only 3 years ago.
Nick Hunter, aggravating. Comment today of law enforcement was not effective, meaning that I needed to take matters into my own hands. Asking for a corrections certification where you're going to be working with sex offenders and outwardly stating that law enforcement was not effective, now going to be in a position where you're going to be faced with those same decisions on a daily basis.
Mike Hartford, for the record, aggravating. I completely agree with the sheriff. While not a protected class, sex offenders, he's clearly shown bias towards sex offenders and having to work with them on a daily basis could prove problematic. Aggravating as well. Both incidents involve violence or threats of violence, and bringing that into law enforcement is problematic, to say the least.
Other aggravating or mitigating?
Nick Hunter, and I'm not sure how to put this one on the record, so I'll do it delicately. I don't find the letter submitted by the lieutenant to be a mitigating factor. In that letter that's submitted by the lieutenant, he completely disregards the incident that took place in 2014. And I believe that is potentially a more significant incident because I think there is clear dishonesty that took place, in the incident in 2014. So I don't find that letter that was submitted to be a mitigating factor.
Cindy, could you read back what we have, please, for aggravating?
Do my best. Cindy Park, for the record. Aggravating, there's a pattern of behavior. I believe there's dishonesty in the stories provided in the 2014 case with the information that Herrera provided leading up to his conviction. Herrera still feels justified in his behavior. The most recent incident was only 3 years ago. Statement of that law enforcement was not effective. He will be working with sex offenders and faced with the same decisions on a daily basis. Shows a bias towards sex offenders. Both incidents show violence or threats of violence. Did not find the support letter from the lieutenant mitigating, and that disregards the incidents that Herrera was convicted on. Does that sound correct with everybody that I read? Okay. Mitigating factors, the hiring lieutenant did write a letter of support. Herrera disclosed and was honest in the incidences. He the statement that he would act within the law. He's completed anger management and maintains a recovery program.
All right.
Mr. Chair, I'd like to add one more. Nick Hunter for the record. Also in that letter of mitigation, or the letter submitted by the lieutenant, basically what his statement was that I don't have anyone else to fill this position, and so if I don't have anyone else to fill this or anyone else applying, then this is going to create a hardship for Harney County. I don't believe that that is the standard that we are holding ourselves to in law enforcement. We are not looking for anyone to fill a position. We are looking for the right people to fill a position. So again, I have an issue with that letter being a mitigation letter.
Okay, any other aggravating or mitigating? Is there consensus from the committee, everything that's been identified thus far? Right, seeing affirmation. Should open a discussion about whether there are moral fitness violations. So as identified, I think staff just identified the misconduct, but Sheriff Hunter has also brought up potential dishonesty. So our actions on this are to affirm, to modify by adding, or to negate and remove all of the factors. So I'd open that up for discussion.
Nick Hunter, for the record, I would make the motion that we modify the factors. I would accept and affirm the misconduct, and I would modify it and ask to include dishonesty as well, based on the 2014 incident, statements made to law enforcement especially during the investigation, and then the end result of the conviction against the statements of the witnesses. I believe there was clear dishonesty.
And Matt English for the record, I had the same kind of concerns. There was a lot of witnesses that were interviewed. They were very consistent about speeds, about where the vehicle was, about being on the wrong side of the road, and that was all minimized. So, sorry, was that a motion?
I think I got the words motion
Okay.
in front of it before.
Okay, so there's a
before everything
motion,
else, so yes.
There's a motion to modify, so to accept the misconduct and to add the element of dishonesty.
Ted Langley for the record, I'd second that motion.
All right, there is a motion and a second. Any further discussion?
We are voting on a motion to modify the moral fitness violations to include dishonesty. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Gorin?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Stefan?
Aye.
Motion passed.
All right, thank you. Let's see. All right, so we now kind of discussed or look for a motion from the committee to recommend action or no action in this case.
Mr. Chair, Nick Hunter for the record, I would recommend that or make a motion that the committee take action in this case based on the outline of the misconduct, confirming that adding of dishonesty, and then the aggravating factors presented.
Thank you. So motion on the floor to recommend action in this case.
Mike Hartford, I'll second.
Thank you. There's a motion and a second to recommend action in this case. Any further discussion? Hearing none. Roll please.
Voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Member Boren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Swafford.
Aye.
Motion passed.
Thank you. So we'll open up the floor now for discussion and recommendation about ineligibility periods. And Kathy, could you kind of walk us through this, or somebody, a little bit, because there was a break, correct?
Chair English, Captain Calvin for the record, that's a different case. So in your review here, the ineligibility would be starting from May 2nd, 2022.
2022.
Yes.
Okay.
Nick and I've got a question for you, Kathy. So, because no certification was ever awarded in this case, so that's what we're actually voting on right now. This is not a revocation of a certification. We're voting on whether this individual, whether Mr. Herrera can in fact be certified.
Yes, and so if you come up with an ineligibility of 3 years, just know that it starts not at the board decision, but in 2022, when the criminal disposition occurred. And Cindy, if there's anything else you want to add, please feel free to do so.
No, thank you.
I'm adding this for the record, so because the committee has affirmed or recommended that there's dishonesty as well, in this case, we would be looking at a potential ineligibility period of 3 years to life.
Nick Hunter for the record, I'll make the motion for a 10-year period of ineligibility based on the recency of the 2022 incident and the aggravating factors of the 2014 incident, demonstrating a pattern of behavior as well as everything else that was shared in this room today.
Brian Seven for the record, I'll second that, and Mr. Herrera couldn't even visit inside the penitentiary until 2026. So I agree with the 10-year.
Okay, there is a motion and a second on the floor to recommend to the board an ineligibility period of 10 years. Any further discussion?
Captain Calhoun, for the record, just so again it's on the record, because we said it in the beginning, why it's even being heard here is because he was previously employed with DOC in Oregon. He didn't reach his certification, so that's why. But this moves it to this committee as opposed to the ARC, which has no previous law enforcement experience.
Thank you. Any other discussion? All right, hearing none. Erica, if you call roll, please.
We are voting on a motion for a 10-year ineligibility period. Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Aldridge,
Aye.
Committee Member Warren,
Aye.
Committee Member Frasco,
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Steffen.
Aye.
Motion passed.
Thank you. Okay, thank you, Deputy.
Thank you.
Next one will be Chris Barnhart. So, first one in book one.
I think I saw John Hart. It's on.
Yes.
Sorry, Mr. Chair, I missed that. Which one are you going to?
Barnhart.
Barnhart.
That's the first one.
Thank you. Okay, I will turn it over to Melissa Langbacha for presentation of the case, please.
Thank you, Mr. Chair. Melissa Langbacha for the record. Corrections Policy Committee members. The department opened a professional standards case for Chris Barnhart after he was terminated from the Department of Corrections following an investigation which found that he took paid COVID leave under false pretenses to travel while other staff covered his time away, which impacted the morale and well-being of his peers. The department found that he was dishonest when he intentionally took leave under false pretenses to travel for vacation purposes, and that his misuse of public funds to take personal paid vacation threatened the credibility and efficient operations of the Department of Corrections. The department is seeking a vote to affirm, modify, or negate the findings. Mr. Barnhart submitted a written mitigation, which is included in the information the committee received for review, and he is appearing today remotely to provide a verbal statement to the committee. Mr. Chair.
All right, thank you. Mr. Barnhart, you will be given 5 minutes to address the committee, and there will be no questions or answers during that period. And when you are ready, staff will start the 5-minute timer.
Very well. I'm ready to go.
All right, go ahead. Thank you.
All right. Thank you guys for allowing me to be here. Sorry that I've put everybody in the position to have to deal with my misconduct, and I presume that all of you have had a chance to read the letter I sent. I'm going to keep it brief today. I served 18 plus years as a correctional officer at Eastern Oregon Correctional Institution in various different capacities, volunteering for any and all different types of committees and groups to try to make things better for my coworkers and for the inmates that I supervised. Did the best I could. I made a bad judgment call. I was dishonest in regards to taking some leave. I modified my initial leave to encompass a 2-week vacation with my wife, who I was worried that I wasn't going to get to go on any more vacations with because of taking a new career. That was a huge mistake. When questioned about it, I was entirely honest on multiple interviews and offered to pay back the funds that I had illicitly gained. I just don't want, for all the good that I did, I don't want to be remembered. It's tough. I made a mistake, and that's realistically where I'm at. I'm just here to beg forgiveness and own the mistakes that I made. That's all I got for you.
Okay, thank you. So does the committee feel like we have enough information to adopt the staff report and move forward in this case? All right, seeing consensus, no objections. Open up the case for discussion for identifying any aggravating and mitigating factors. Just remember to state your name for the record, please. Floor is open.
Jennifer Cameron, aggravating factor, the dishonesty. When I reviewed his letter, it talks about a mistake. This isn't a mistake. This is a decision that was made. And I think that's mitigating. It was purposely done, and that's just not acceptable.
Aggravating.
Aggravating. Yes, thank you. Sorry.
Ted Langley for the record. I echo those same thoughts, but just to expand on that a little bit, he seemed to rely heavily on, or lean heavily on, the mitigating letter, but that doesn't negate the consequences for the actions. I also wanted to point out that I felt like the letter that was submitted almost blamed the superintendent for the termination, rather because he had offered to pay to pay back the money that was stolen. So I find both of those factors aggravating. I will I will submit that I felt like when he was questioned, he was truthful. I'd find that as a mitigating factor in the case too.
Thank you.
Nick Hunter for the record. Aggravating, I see no demonstration of accountability going off of Captain Langley. I will agree that there was, you could look at that he was going to pay the money back, but remember, this is only when he got caught. I come back to Vice Chair Cameron and what she said, and this was very clear that this was an intentional act that we are trying to classify as a mistake. James reasoned when we look at a mistake is something that you do not know the process. In this case, Mr. Barnhart clearly knew the process and intentionally deceived that process. I believe it is aggravating that he extended that COVID leave even more, knowing that he was going to use that COVID leave to take that vacation.
And Matt English, for the record, just to kind of add on to that, I kept coming back to if that Facebook photo hadn't been posted, would he ever have taken accountability?
Brian Steffen for the record, aggravating. Barnhart consistently violated public trust by manipulating COVID protocols to get the paid time off. He would leave the country knowing that when he came back he had to isolate for a certain amount of days on his multiple vacations, using the FMLA to do that. He utilized a program that was a good thing and turned it into something bad. The dishonesty, he admits it now, but the I felt purposeful confusion caused by what day he was tested and where he went. It was also aggravating. Failed to return to work on December 23rd, made sure he had Christmas off, said that he was told to do that. The person he said told him to do that didn't. Let's see, and this was all aggravating also because it was at a time when USCI was critically low on staff. Other people had to cover through mandatory overtime, couldn't be with their families while they were covering him while he was on vacation.
Thank you.
Nick Hunter, aggravating. His statement today still does not demonstrate accountability. His statement today is that he doesn't want this to be the way his name is left. Not that he's taking accountability for what he did and the intentional acts, but he does not want his name to be left this way. That does not demonstrate accountability.
Other aggravating, mitigating? Melissa, would you recall what we have so far, please?
Melissa Langbasha, for the record. For mitigating, I have that he was truthful during the investigation into his conduct. And for aggravating, I have that he talks, that Barnhart talked about his conduct being a mistake, but it was purposeful. He demonstrated no accountability for his conduct, which wasn't a mistake, and intentionally extended leave to take a vacation. He relied heavily upon his mitigation letter, which almost blamed the superintendent because he wasn't allowed to repay the time that he took off. If the Facebook photo was not posted, would he ever have taken accountability? The committee questioned whether he would have ever taken accountability. He used leave for that was intended for good purposes, to allow people to tend to their children, for bad purposes for his benefit. His additional instances of quarantining were aggravating factors at a time when the staffing was critically low at the Department of Corrections. His statement today also did not demonstrate accountability, but rather he wants to, how he wants to have his name reflected. Mr. Chair.
Thank you. All right, is there consensus around everything that's been identified thus far? Any objections? Are there any additions? All right, hearing none. I would open a discussion about whether we affirm, modify, or negate what has been identified through discussion and by staff, which is dishonesty and misconduct. So looking for a motion.
Brian Steffen for the record. I move that we affirm.
Thank you.
Nick Cutter. Oh,
Go.
Jennifer Cameron, I second.
All right, thank you. There's a motion and a second to affirm the dishonesty and misconduct as identified.
We are voting on a motion to affirm the moral fitness violations. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Bourne.
Aye.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Sutton.
Aye.
Thank you. Okay, so looking for a motion to recommend to the board whether they take action or no action in this case.
Brian Steffen for the record. I recommend to the board, move that we recommend to the board that they take action.
Thank you.
Mike Hartford, I'll second.
Thank you. It's been moved and seconded to recommend action in this case. Eric, if you call roll, please.
Voting on a motion to take action. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Bourne.
Aye.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
Thank you. All right, floor is now open for discussion and a motion on recommended ineligibility period in this case because dishonesty was one of the factors recognized. We're looking at a recommendation between 3 years and lifetime.
Mr. Chair, quick question for Deputy Director McAlpine. When does this ineligibility period start?
Catherine Calvin for the record, April 9th, 2021.
All right, thank you. Nick Hunter, for the record, I'll make a motion based on the combination of dishonesty and misconduct. I'll make the recommendation for a 10-year period of ineligibility.
Lori Frosco for the record. I have a second.
Okay, further discussion? All right, hearing none, there's a motion to recommend a 10-year ineligibility period in this case.
Voting on a motion for 10-year ineligibility period. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Bourne.
Aye.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
All right, thank you. And thank you, Mr. Barnhart, for being here. All right, we will move on to Justin White, which is in Book 2, the second case.
And he's not on one.
Not.
Oh, okay, here we go.
Well, since we moved here, we'll do it anyway.
There you go.
All right. Okay, so Jennifer Lavario, I will turn it over to you.
Thank you, Chair English. Jennifer Lavario for the record. Good morning, members of the committee. Before I start, I did want to point out a correction in the report that I gave you. The page that identifies the ineligibility start date is inaccurate. The ineligibility start date would be the date of the board's review, which is July 24th, 2025. And that is because Mr. White is employed right now with the Department of Corrections. This case has been going on for quite some time, so there was interruptions in his employment, and now he's back employed, so that part got missed. In addition to that, if action is taken, I just want to point out that the rule provides for a certain amount of time to be, I'm trying to get the word, waived, suspended? I don't know. Credited, thank you. That's the word that just wouldn't come out. Credited for the time that he was separated as a result of the initial case being opened for a moral fitness violation. So Mr. White was separated for a period of time. It was 19 months and 14 days. So when if action is taken, this is an if, that would be part of your considerations, that it would date back to, let me tell you what that is, December 10 of 2023 would actually be the start date. Hopefully I'm not confused that matter too much. Is there any questions about that? That's a bit confusing. Okay. All right. So this is a case involving Justin White. The department opened a professional standards review after Justin White was terminated from the Oregon Department of Corrections Two Rivers Correctional Institution on April 10th of 2019. Mr. White was terminated for declining to fulfill an overtime request and receiving a driving under the influence and reckless driving charge in Washington State on November 10th of 2018. Mr. White grieved his termination and went to arbitration. While reviewing the current separation, the department became aware of a criminal disposition that Mr. White did not report to the department while he was employed at the ODOC, Oregon Department of Corrections. Mr. White was cited for failure to stop, give information, or aid, a misdemeanor, on March 12th of 2016. This case was diverted and consequently dismissed on June 13 of 2017. So going back to the arbitration, the arbitrator determined that Mr. White should be reinstated to employment. However, the arbitrator also determined that there was misconduct in the case. Per Oregon administrative rule, that allows the department to, even though he's reinstated, to continue with our review because the arbitrator determined that there was still misconduct on the table. On November 17th of 2021, Mr. White pled guilty to reckless driving, an amended judgment from the original charges of DUI and reckless driving. On September 3rd of 2022, Mr. White's employment was transferred to the Eastern Oregon Correctional Facility, where he's now employed. And the department did determine that Mr. White violated the board's moral fitness standards in terms of misconduct. Mr. White violated criminal law while employed as a corrections officer and admitted to driving under the influence of alcohol. Mr. White's conduct threatened harm to people and property and violated the Criminal Justice Code of Ethics. Additionally, Mr. White violated several laws while employed as a corrections officer, which threatened harm to people and property, the totality of which, along with DUI and reckless driving, evidenced a disregard for the traffic laws for both the state of Oregon and the state of Washington. As a corrections officer, Mr. White was responsible for holding adults in custody accountable for their actions related to rules and laws. Corrections officers are expected to provide an example of behavior that aligns with sound judgment and rule-abiding behavior. Chair English.
Thank you. Is the committee, is there consensus that there's enough information in the staff report to move forward with this case? Any objections? All right, I'll open up the case for discussion. And to identify any aggravating and mitigating factors, please remember to state your name for the record.
Brian Steffen for the record, aggravating factor, it appears that he continues to disregard the law, particularly regarding speeding violations in multiple counties in Oregon and in the state of Washington.
Matt English for the record, aggravating factor, his mitigating letter. It was, there was no responsibility. It was blaming everybody else. And then also I was real troubled with the amount of traffic violations. I count 8 that are outside of the criminal conduct as well. And they continue into 2024, and there's a lot of excuses in the mitigating letter about them, so I'm really concerned about the lack of accountability.
Nick Hunter, for the record, I'll kind of add on to what Sheriff English said, and I will use the word pattern of behavior. There is a pattern of behavior for disregarding the laws of this state, and clearly the laws of the state of Washington as well. Nick Hunter, for the record, aggravating 102 miles per hour on a motorcycle is also putting the public significantly in jeopardy, and it is disregarding the value of human life. Nick Hunter, for the record, aggravating. The arbitrator did clearly find misconduct, however, it was a procedural issue that returned Mr. White to work at DOC.
Other aggravating and mitigating.
Kind of for the record, I don't think we put it on the record, but aggravating is the criminal conduct as well that he was charged with.
Mr. Chair, Josh Aldridge for the record. I believe aggravating circumstance. I don't see that he ever reported his encounters with law enforcement appropriately, either to his employer or DPSST.
Thank you. Any other aggravating, mitigating?
Nick Hunter, for the record, based on what Josh just said, failure to report to DPSST brings into question dishonesty because we are now omitting items, and lying by omission is a form of dishonesty.
Jennifer, can you read back what we have so far, please?
Yes, thank you, Chair. This is Jennifer Lamario for the record. I did not record any mitigating circumstances. The aggravating circumstances are that Mr. White appears to continue to disregard the law through his continued traffic violations. There was a sense that the mitigation letter, was not mitigating but aggravating because he took no responsibility and blamed others. The traffic violations continue into 2024, which also shows a lack of accountability. He has a pattern of behavior for disregarding the laws of the state of Washington and Oregon. 102 miles per hour on a motorcycle is putting the public in significant jeopardy and disregards the value of human life. Even though the arbitrator reinstated Mr. White due to a disciplinary process at DOC, they did find that there was misconduct. His criminal conduct is aggravating. His failure to report his criminal conduct appropriately to the DPSST and DOC brings up dishonesty in terms of lying by omission. And I believe that's what I have.
And Chair English, Catherine Kalpine for the record, Member Hunter, just want to clarify with everybody else and the dishonesty. The dishonesty, failure to report to DPSST can be an aggravating factor, but to add it to a moral fitness violation, it's an Oregon administrative rule. Not everybody knows all of our rules and abide it. So it'd definitely be appropriate to put it as an aggravating, but to add it as a moral fitness violation for just failure to, lack of reporting to us would not be recommended.
Thank you. All right, is there a consensus around what the committee has identified? Any additional aggravating or mitigating? All right, hearing none.
Just a second, Mr. Chair, just one quick question. Sorry, Nick Hunter for the record, Deputy Director McAlpine. Does the same thing go for a single occurrence versus multiple offenses?
Catherine Kalpine for the record, I'm going to turn it over to my rules coordinator just to get some advice. I'm going to phone a friend here.
Jennifer Howell for the record. So clearly considering it as an aggravating factor is the discussion currently on the table, and that's fine when you all get to the decision on whether or not there was a moral fitness violation that rises to the level of intentional dishonesty when we don't have anything necessarily in the record that would indicate this person knew that there was a requirement to report to DPSST and violated that knowledge and purposefully didn't report. I don't believe that that is part of the records that we have that it would support or not support that
I think you're correct.
finding.
Nick Hunter for the record, I'm satisfied with the explanations I have now been given. I appreciate that, thank you.
All right, so we'll open up for discussion and a motion on adopting the moral fitness violations. So our actions can be to affirm, to modify, or to negate.
Nick Hunter for the record, I'll make a motion that we affirm and accept the staff report as it was completed, highlighting misconduct.
Okay, there's a motion on the floor to recommend affirming misconduct.
Josh Aldridge for the record, I'll second.
All right, there's a motion and a second, so Eric, if you do roll, please.
We are voting on a motion to affirm the moral fitness violations. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Boren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Stefan.
Aye.
Motion passed.
Thank you. So looking for a motion to recommend to the board whether they take action or no action in this case.
Ted Langley for the record, I recommend the board take action in this case.
Brian Steffen for the record, I second.
Thank you. Any further discussion? All right, there's a motion and a second to recommend to the board to take action in this case. Erica, if you could call roll, please.
Voting on a motion to take action. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Member Boren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
Committee Member Steffen.
Aye.
Motion passed.
Thank you. All right, floor is open now for discussion and a motion regarding the recommended ineligibility period in this case. Because we're dealing with misconduct, we can recommend between 3 and 10 years. And please, the first motion should indicate why the recommended time period is being recommended.
Ted Langley for the record. I'm making a motion for a 10-year ineligibility period based off of, and I'm going to use the Sheriff Hunter's words that he's used a couple times already, and as the pattern of the driving infractions, and also because in conjunction with the excuses that were made in the mitigating letter, even though there was no intentional dishonesty found, failing to report it still feels dishonest.
Okay, so there's a motion on the floor to recommend a 10-year ineligibility period.
Josh Aldridge for the record, second that recommendation and add the aggravating factor that he's continued to not take any accountability for his actions.
Thank you. Any further discussion? All right, there's a motion and a second to recommend 10 years of ineligibility to the board.
We are voting on a 10-year ineligibility period. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Bourne.
Aye.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
Thank you. All right, we're going to skip ahead again in the agenda for a few minutes to allow Director Castle to do an update, because he has a conflict coming up. So I'll turn the floor over to you, Director.
Chair English, thank you very much. Co-counsel for the record, members of the committee, I appreciate the time to be able to talk to you today and for forgiving me for jumping ahead on the schedule a little bit. One, I always like to do this because this is an enormous commitment when you're referring to different volumes that you need to flip to proceed with a case, right? There's a lot of reading that you all have to do, and it's a big time commitment, and all of you have very, very busy lives and jobs and so forth, so I'm super grateful that you're willing to do this service that's super important and pretty challenging to do. So thank you very much for that. I also want to encourage all of you, your voices are all very important, and when we're discussing cases, the more discussion there is, the more rich the record is, and that's really, really important for this process. So, you know, if you feel like something is redundant that you have to say, that's okay. I just want to encourage you to go ahead and say it. Even if you're online, you feel like it's being represented in the room, please do feel free to participate. It really helps the record. I also want to say that these take a tremendous amount of work to prepare for, and the staff to my right does an unbelievable job of doing that and keeping this incredibly professional, what they do. So I want to thank them very much for all the work that goes into this. And I have an announcement to make. Unfortunately, I need the deputy director here to do other things rather than all the things which she is currently doing. And so we have been very fortunate to find a fantastic, I don't like to say replacement, but a new director of our professional standards division, who I'd like to introduce, is Maria Atwood.
Hello.
Marie Atwood is currently our legal coordinator, so she is an attorney, which is awesome, and she brings a tremendous amount of experience, and I'll let her tell you about that. some other time. I'll let her tell you about all that, but she brings a tremendous amount of experience in the municipal side and now on the state side, so it'll be a great benefit for DPSST and this committee and all the rest of the board. So we're very happy. She'll be starting on July 1st. So that's great news. Legislative session is moving right along for DPSST, and we have been spending a lot of time at the Capitol. There's a lot of bills that have DPSST's name on it, and I would say that in a mostly positive way. And our bills seem to be moving along quite swimmingly. We had two agency bills move out of committee yesterday, right? Which is a great thing. One of those was just a technical fix to how we appoint people on the Fire Policy Committee. The second bill is the big one for us and relevant for you. It allows us to adjudicate cases of non-certified folks, which right now we have roughly 150 of those folks who are in the non-adjudicatable purgatory, if you will. And it's a gap in the OAR that will be closed with this legislation, and it's being widely supported. We have our financial bill that is going to be heard. It's 5032, and then 5033 will be heard next week on Wednesday at Public Safety Subcommittee for Ways and Means, and then will be heard by full Ways and Means on Friday. I want to thank the folks that testified on behalf of the DPSST, including our own Sheriff Hunter, thank you very much. Of course, Chair English, thank you very much for testifying for us. We had a lot of people show up to testify. We had a lot of support. Almost no comments from anybody in the legislature other than support. So very well received. I am not expecting any issues next week, but both Kathy and I will be there for that, and so we're looking forward to that. I did want to talk a little bit about our F building. Our F building, which is our mini city, if you will, that's down in our cold zone on the north side of DPSST. We have, you may remember this, we went to an E-board to get money to repair that building. We have structural damage in that building caused from a design defect. The building was not designed for internal wind shear. It was only designed for external wind shear. And that building has very large doors on either end of it, which gives it the opportunity to receive that wind shear from the inside. And it's caused some serious structural cracks on the inside of that building. It is a major, major training space for us. And we train 12 months out of the year, so we do not have the ability to vacate that building in a good way that doesn't impact training and even safety. So it was critical that we start to move on that before the building becomes uninhabitable, which it could very well do should it continue on. The bad news is I made a mistake in the way I requested that money. I requested that money not knowing I would need to extend it to the past the biennium. The good news is we were able to solve that with the legislature. We were able to work with them to get them to allow us to transfer money over. So I'm very grateful that they forgave my oversight on that. So we are making some good progress now moving forward on the fixing of that building. We do believe we'll be able to fix it incrementally, meaning not having to close that building while we fix it. Can fix we're strategizing on which parts we can fix when, based on our training schedule and so forth. So that's going to be great for our students. They're not going to be losing out on training experience or safety or anything like that for that. I think that is all. I wanted to open the floor up for any questions that you may have of me.
Matt English for the record, just so all agency budgets are still on hold, is that correct?
They're hearing ours next week, so that was the revenue forecast comes out
Friday.
Tomorrow.
Oh, tomorrow.
Right, revenue forecast comes out tomorrow. I don't expect anything shocking to come in that revenue forecast that I've heard. So yeah, they are kind of holding, and from what I hear, the legislature is just a little nervous about, the potential for federal impacts to our budget and so forth. So they are going to be, I've been told, a little shy on that, so understandably so.
And just for, I guess, confirmation, within that package is another investigator position, right, to help with the backlogs?
Correct, absolutely.
Excellent.
And that's Pop 102. Any more questions for me? But I do have one other thing I need to do.
Yet again.
You knew this was coming. I'm getting tired of doing this, Chair. But I do want to recognize Chair English for all of his service. We've already done this once already at the main board, because as you know, Chair English is also the chair of our board, who has been, now we have a replacement. Does everybody know who Chair English's replacement is? It is Superintendent Cotting. He will be the new board chair, and then we have Deputy Fire Chief Chris Heppel is going to be our vice chair for the board. But Matt, thank you for all your years of service. 9 years.
Yeah.
9 years here at DPSST. Really grateful for all your service. And he's spent so much time here that we should have built him an office. But we'll have some kind of memorial office for you. And you're always welcome. Yeah. You're always welcome.
Okay, back on business.
All right.
Book one?
Yeah.
Barrier?
Yes. All right, we will move to Philip Barrier, presented by Melissa Langbacho.
Melissa Langbacho for the record. Good morning, Mr. Chair and the Corrections Policy Committee members. The department opened a professional standards case for Philip Barrier after he resigned from his position with the Lane County Sheriff's Office during an investigation into allegations that he fell asleep while on duty, failed to complete welfare checks of adults in custody, and then falsified records to reflect that he had completed checks while he was asleep. The department's review also includes criminal dispositions that were not previously reported or reviewed by the department. In 2022, Barrier entered a plea of no contest to reckless driving, and in 2024, he pled guilty to reckless driving and driving under the influence of intoxicants. The department found for dishonesty that Barrier had intentionally falsified records to reflect that he conducted observation checks of adults in custody at the time when he was asleep. Barrier intentionally falsified records to reflect that he conducted checks on 8 adults in custody when he did not check on those adults in custody. Barrier was intentionally dishonest with police officers when he provided multiple false stories as to how his vehicle was in a crash. And for misconduct when he failed to check on adults in custody as required, he threatened the efficient operations of the Lane County Sheriff's Office. Barrier's conduct harmed the safety and security of the facility and the adults in custody, and also put the Lane County Sheriff's Office in a position of great detriment by not performing legally required welfare checks on those in their custody. Barrier violated criminal law and received criminal dispositions for two counts of reckless driving and for driving under the influence of intoxicants. His conduct threatened or harmed persons or property when he recklessly crashed into 2 vehicles, causing property damage and endangering people around him. Mr. Chair.
Thank you. All right, is there consensus from the committee that we have enough information to move forward? We can adopt the staff report. Seeing affirmative and no objections, we'll open up the case for discussion to identify any aggravating and mitigating factors. Please remember to state your name for the record.
Nick Hunter, aggravating factors. One, that he had previous counseling about sleeping while he was on duty. The criminal acts are an aggravating factor. Multiple criminal acts are an aggravating factor. And I think there was another situation of sort of forced accountability here versus him actually taking accountability for his own actions. The stories that he told were his attempts to mitigate his own situations as opposed to simply accepting his own fate and his own actions. So there was a complete lack of accountability.
Ted Langley for the record. As an aggravating factor, actually two of them, I'd also say that as a corrections deputy, the things he lied about are quite literally the most important core responsibility a corrections deputy has. And in lying about something that is at the core of his job, it's a violation of the trust that's put in us by the public, of what we do, what we're getting paid to do. Without the public's trust, we don't have anything. So the fact that that responsibility is a core responsibility, I think, is aggravating. Also, the fact that some of those people that he ignored were in a high risk category in the facility, which just amplifies the level of dishonesty.
Mike Hartford for the record. I completely agree. The suicide watch checks that he missed, the intoxication watches that he missed, not only put the safety and security of the facility at risk and the sheriff's office at risk, those people that were suicidal and potentially suffering intoxication issues could have died because he missed those checks. It's a serious violation.
And Jennifer Cameron, for the record, I agree. That was something I was going to mention, the fact that these people are on suicide watch and he missed that. I mean, we have a duty to protect the vulnerable people, regardless of what they've done or whatever, and so I find that aggravating.
Nick Hunter for the record, because Captain Langley did not get it on there. There's actually a pattern of dishonesty, both within the workplace and outside of the job. I'm not sure after reading this what he was actually honest about, but we do need to get the pattern of dishonesty on the record, sir.
All right, additional aggravating or mitigating?
Josh Aldrich for the record. Once again, Mr. Barrier did not report his criminal conduct to DPSST appropriately, which is an aggravating factor.
Just not lying by own, never mind.
Mike Hartford for the record, aggravating. The stories that he concocted about what happened to his vehicle and who took it and what happened as a result of these incidents clearly indicate intent and a clear intention to make up wild and unbelievable stories regarding what happened during that incident. So not only just dishonesty, but like clear intent and manipulation of those situations.
Nick Hunter for the record, aggravating. There is a complete disregard for the value of human life, whether we're discussing the AICs that he was supposed to be performing routine checks on, or the fact that he ended up striking another vehicle and made no attempt to check on that driver or anything else in that situation, knowing that he had been involved in a crash.
Brian Seven for the record, aggravating. The repeated and consistent false statements would render him completely useless in court, which would be a part of his job as a correctional staff.
Sorry.
Giving Melissa time to write. Just being respectful.
I appreciate the extra moment there to finish scribbling. Melissa Ingbacha for the record, to summarize the aggravating and mitigating factors identified by the committee. I didn't hear any mitigating factors identified, but for aggravating, have noted that he did not report his criminal contacts to DPSST. He had previous counseling about sleeping on duty. There were his multiple criminal acts were aggravating. He was forced to take accountability instead of choosing to take accountability on his own. The things he lied about were core functions for deputies, and in lying about those core functions, it violates the public's trust in the role of the Department of Corrections. Some of the people he failed to check on were on suicide or intoxication watches, which elevated the risks associated with his failure to check on them. He has a duty to protect the adults in custody. There was a pattern of dishonesty both on the job and off the job. The stories that he concocted about the accidents demonstrate a clear intent to manipulate circumstances. He had a disregard for others, both adults in custody by failing to check on them and in striking vehicles and making no attempt to contact the owners. His repeated instances of dishonesty would render him unable to testify in court, which is another core function of his job. Mr. Chair.
Thank you. Any other aggravating or mitigating? Do we have consensus about everything that's been identified? All right, seeing consensus.
Motion?
What's that?
Said you want a motion? Nick Hunter for the record, I'll make a
No,
motion.
we don't need one yet. We'll do that. What's that?
Oh. Gotcha.
Yeah, well, this is the time for a motion. Is the, to affirm, modify, or negate the moral fitness violations, which are dishonesty and misconduct.
Brian Steffen, I make a motion to affirm.
Ted Langley, second.
All right, there's a motion and a second to affirm the moral fitness violations of dishonesty and misconduct.
We are voting on a motion to affirm the moral fitness violations. Chair English?
Aye.
Vice Chair Cameron? Aye. Committee Member Aldridge?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
Thank you. All right, so floor is open to recommend a motion to take action or no action to the board. I would like to give Sheriff Hunter the first crack at this.
Listen, I was gonna, Mr. Chair, respectfully, the motion that I was gonna make, that Ted just took my motion from the last one, because you denied me, but I will make a motion for a recommendation that the board take action based on the identification and the adoption of the staff report, and then the aggravating factors of dishonesty and misconduct.
Okay, there's a motion to recommend to the board to take action. Is there a second?
Lori Frasco for the record, I second.
Thank you.
All right, voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
Thank you. The floor is open now for discussion and a motion about recommended ineligibility period, in this case to the board, because we have identified misconduct and dishonesty. We are considering a recommendation between 3 years and life.
Nick Hunter, for the record, I'll make a motion for a lifetime revocation based on the multiple events of dishonesty, criminal conduct that was involved, the continued patterns of behavior demonstrated by Mr. Barrier, I believe, and the complete lack of accountability during those instances would support, or I believe support, my recommendation for a lifetime revocation.
Brian Seven for the record, for the same reasons, I'll second.
Thank you. So there's a motion and a second to recommend lifetime ineligibility. Is there any discussion? All right, hearing none.
Josh, I would just like to add, the Lane County management team looks like they clearly did it. They've made every effort to give this guy an opportunity, and he ignored every one of those.
Thank you.
All right, we are voting on a motion for a lifetime ineligibility period. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bourne?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Stefan?
Aye.
Motion passed.
Thank you. Okay, we will move to number 6 on our agenda, Peter Collins. And this case is presented by Melissa Lynn Basho.
Melissa Lynn Basho for the record. The department opened a professional standards case to review the circumstances of Peter Collins' termination from the Douglas County Sheriff's Office following an investigation into his failure to complete security checks of adults in custody while reporting that he completed the checks. The department found dishonesty, that Collins intentionally falsified records to reflect that he conducted security checks that he did not conduct, and misconduct. Collins created an inefficient operations of the Douglas County Sheriff's Office by falsifying information to reflect that he conducted state-required security checks, which he did not do. This falsification of the records threatened to harm the reputation or official standing of the Douglas County Sheriff's Office. Collins threatened the health and safety of the adults in custody by failing to confirm the safety and welfare of the adults in custody. Mr. Chair.
Thank you. Matt English for the record, just a question for staff. Are you aware of any other cases involving this gentleman?
I'm not. However, if there's information that should be included, I definitely can seek out additional information and review that.
Matt English for the record, I think there's plenty here. I think that for the staff report, I just think there maybe was something after separation or something that may come back around at some point. I think he's a resident of Oregon Department of Corrections. But do we have enough information to move forward on this case on the dishonesty?
Mr. Chair, I guess I would just pose the question, if you think there is something else, do we just want to push this one down the road to give the opportunity to find out any more information? Not that there isn't enough information to make a directional move right now. I would just say let's get it all on the record, because if he is a resident of another location at this point, I don't think there's any immediacy for needing to make this decision today.
Matt English for the record. It's my understanding that he had a theft 1 conviction that has, there's been disposition on that. And so I don't know how new that is.
I don't know.
It sounds like it was on Friday.
Yeah.
What's that?
Cindy Burke for the record just looked at the information. He is indeed a resident of the Department of Corrections.
And at this time, DPSST wasn't notified of that conviction, so he's a little tied up, he's not performing the duties. Very easily could get all that information and then bring it back to this committee, hopefully maybe the next committee meeting in August.
Do you need a motion for that, or is that just something we can?
I think by consensus, we can return it to staff for more information.
I'm not 100% certain, but if there are felonies, which there may be, it wouldn't come back to the committee.
Maybe a mandatory.
Yeah, it's a conviction for felony theft. So that includes a component of dishonesty, correct, in the presumption?
Yes.
So no deception.
So, yeah, if it's a consensus, we will pull this off the agenda and add the additional information.
Consensus around that? Okay, thank you. Sorry to throw a wrench in that.
No, I appreciate the info.
Just learned about that. It wasn't like I was withholding it, so. All right, we will move on to item number 7, James Damon. Also presented by Melissa Lang-Bacha.
Thank you, Mr. Chair. Melissa Lang-Bacha for the record. Chair and Corrections Policy Committee members, the department opened a professional standards case to review the circumstances of James Damon's resignation from the Department of Corrections during an investigation that he falsified check and count records to reflect that he had conducted checks that he did not complete. The department found that Damon intentionally falsified Department of Corrections records to reflect that he conducted required count checks when he had not completed them. Damon failed to conduct counts and checks on people in custody of the Department of Corrections, which threatened the safety of the DOC facility, the community, and the people in the custody of the facility. Mr. Chair.
Thank you. Do we have enough information to adopt the staff report and move forward in this case? Seeing consensus, no objections, open up the case for discussion to identify any aggravating, mitigating factors. Please remember to state your name for the record.
Ted Langley for the record. Again, we're talking about untruthfulness of not performing a very core act of somebody that works in corrections. And I would offer also that with almost 19 years in that discipline, it just absolutely compounds the effect of his untruthfulness. Not that there's ever an excuse, regardless of your time in the discipline, but that 19 years is just like an exclamation point at the end of it. But, and, sorry, Ted Langley for record, along with that, I mean, we're not talking about one instance. We're talking about, if I remember right, it was, I think it was 9 of them that they said they pointed out. So it wasn't just one instance of falsifying a record, it was 9 of them.
Mike Hartford for the record. Aggravating, while I agree with the pattern of behavior for lying about the checks, he also, when he was, during the investigation, he offered up multiple scenarios in which he could possibly not be held accountable for missing those, whether it was he was attributing the checks to somebody else, whether it was a different type of check, like a PREA check, regardless, where he knew he was the one that was supposed to be doing the check. He was saying that he may have documented somebody else's check.
Nick Hunter for the record, aggravating, building on what my two peers have been talking about here. There's an intentionality to this. And I get the intentionality from his comment where in the end he's asking for similar treatment to how everybody else has been treated that's been involved in this situation. And so he is clearly very aware of what his responsibilities are, what others have done, how others have got around doing these type of things before. And so there is a clear no accountability for any of his actions. And I would go as far as to say that he was scheming the system all along until he was called on what he was doing. But I think the demonstration of sort of intentionality towards not doing the checks was what bothered me the most.
Other aggravating, mitigating? Melissa, can you count what we have, please?
Yes. Melissa Langbach for the record. I didn't hear any mitigating factors identified, just aggravating. For aggravating, I have that he failed to conduct a core function of his job by not checking on the adults in custody. He had 19 years of experience, which aggravated his failure to do the checks. It was not just one incident, but 9 were identified. There was a pattern of behavior. He did not take accountability for his conduct during the internal investigation, and there was it was intentionally done because he was asking for similar treatment to those who've done the same thing in the past, and that he intentionally did not conduct checks, Mr. Chair.
Thank you. Is there any other aggravating or mitigating consensus around what's been identified thus far? All right. So open discussion about whether there's moral fitness violations. So looking for a motion to either affirm, modify, or negate. And in this case, we have dishonesty and misconduct.
Jennifer Cameron and I will make a motion to affirm the misconduct and the dishonesty.
Thank you.
Mark Warren for the record, I'll second.
Thank you. Any further discussion? There's a motion and a second to affirm the dishonesty and misconduct.
All right, we are voting on a motion to affirm the moral fitness violations. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
Thank you. The floor is open now to recommend to the board to take action or no action in this case.
Josh Aldridge for the record. I recommend the board take action in this case.
Thank you.
Ted Langley, second.
Thank you. There's a motion to recommend to the board to take action in this case. Any further discussion? Hearing none, call for the roll, please.
Motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Warren?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
Thank you. Floor is open now for discussion and recommendation to the board for a period of ineligibility in this case. Because it's dealing with misconduct and dishonesty, we're looking at a recommendation between 3 years and lifetime. And if you make your first motion, please state on the record why you are recommending that specific period of ineligibility.
Brian Seven for the record, I would make a recommendation of lifetime, based on the report and the aggravating factors, and the reason that lifetime is on the table for dishonesty is because you can't take it back, and he's not going to be able to testify in court, which is part of the court responsibility.
Nick Hunter, for the record, I would second that lifetime ineligibility. The gross misconduct and the intentionality, sorry, there you go, Melissa, I used that word again. That what he was asking for was to be trained again on something that he clearly already knew and just intentionally chose not to do, and then falsified the records. So I believe the gross misconduct and the dishonesty together support that recommendation for lifetime ineligibility.
All right, thank you. Any further discussion? All right.
We are voting on a motion for a lifetime ineligibility period. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Member Boren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
Thank you. Okay, we will move on to item number 10, CPC Chair and ARC Committee nominations. Deputy
Captain
Director.
Calpine, thank you. Captain Calpine for the record. First, I'm going to carry over the Corrections Policy Committee Chair until the August. Right now, currently, the only one eligible is Vice Chair Cameron. She is more than willing to chair the August one, and then we should have a discussion of two people that will be eligible for the chair position. So I'll move on from that one. If you're not familiar, we need a representation from the Corrections Policy Committee for the ARC, the Applicant Review Committee. Again, that is, by all accounts, a much lighter lift than what you do here. We're talking anywhere from 1 to 3 cases. These are individuals who have been hired to come into our profession but do have a criminal disposition that needs to be reviewed. Generally, everybody attends those virtually. Sometimes we don't have anything. These are monthly so that we can be timely in deciding whether or not to let somebody into the academy. And so from a comparison, it's a lighter lift, but it also would be added to what you already do. Who is eligible is Ted, you're eligible, John Frost, Brian Steffen, Margot Tabor, both are absent, so if anybody who's willing to step up would be greatly appreciated.
I'll do it.
Thank you, Ted. Absolutely appreciate it.
Ted was whispering earlier about opportunities he's been looking for, so.
Yes.
That'll be good at it.
Hopefully in
I'd
those
make it
there
too.
won't be patterns, because hopefully then we're not hiring him, but yeah, still give me some. Oh, okay, did somebody have their chair, did you see a hand up?
I didn't.
That was me.
Oh, John, you were willing to step up
Frost,
as well?
yeah. Yeah, John Frost for the record. Yeah, I would take on that if
So,
needed.
obviously still willing to do it, but I've actually sat on that committee before, and if you'd like the opportunity to see what it's like.
Well, the fact that you were willing to do it should indicate, John, that, John, if you're willing to do that, I do believe we need a vote by the committee to do that.
The charismatic nature of Ted's deflection right there. Outstanding.
So do you need a vote, correct?
Deputy
Yes.
Director, do you need a motion to get to that vote then?
Yes, please.
So I'll make a motion that John Frost become the new member of the ARC or ARC representing the CPC or Corrections Policy Committee.
Matt English, I'll second.
All right, we're voting on a motion to nominate John Frost to the Applicant Review Committee. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Warren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
I guess I vote for myself. Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
Committee Member Steffen.
Aye.
Motion passed.
All right, thanks, John, for stepping up.
Yeah, thank you. I'll keep it light on the updates. Again, Catherine Calpine for the record. I just want to add a little bit more explanation or bio for Marie. 11 years at Washington County DA's office. Had the pleasure of having some robust conversation where I think she's an exceptional candidate to take this position even higher. And she's an adjunct professor at Lewis and Clark, right?
Yeah.
Right? And she is absolutely excited. In fact, we're having to hold back from starting her any sooner than July 1st. But I think you will be very pleased. And we'll give an opportunity for you to get to meet her a little bit more after this meeting. So other than that, that's all the updates we're going to do for you.
All right. Anything else for the good of the order? Just wanted to thank everybody. This has been a great honor for me to be able to serve in this capacity for so long, and the staff here is incredible. I've got to work with a lot of incredible people, and so I know you'll keep fighting the good fight and doing excellent work. And then for all the committee members, I've had the opportunity to work with many really professional, dedicated people that sit on this committee, and it's really impressive, and it's been really humbling experience. So I appreciate the opportunity, and I really am going to miss this. So thank you, and good luck, and